What is contributory infringement? Contributory infringement is a form of indirect patent infringement that occurs when someone supplies a component or material that is specially made or adapted for use in a patented invention, knowing that it will be used to infringe, and that component has no substantial non-infringing uses. In simple terms, a company can be liable for contributory infringement if it helps others infringe by providing the essential tools or parts, even if it does not directly practice the invention itself. The legal foundation for contributory infringement comes from 35 U.S.C. Section 271C, which states that whoever sells or offers to sell a component of a patented invention, knowing the same to be especially made or especially adapted for use in an infringement, and not a staple article or commodity of commerce suitable for substantial non-infringing use, shall be liable as a contributory infringer. The origins of this doctrine lie in early 20th century patent law. Before Congress codified it in the Patent Act of 1952, courts had recognized contributory infringement as an equitable principle to stop people from indirectly profiting off infringement. Lawmakers included it in the statute to provide clarity, balancing two interests: preventing unfair assistance in infringement while protecting sellers of ordinary goods that happen to be used in patented inventions. The essential elements of contributory infringement are direct infringement by another. Someone must actually use or make the patented invention. Without direct infringement, contributory liability cannot exist. For sale of a component. The accused infringer must supply a part or material of the patented invention. Special adaptation. The component must be specially made or adapted for infringing use. No substantial non-infringing use. If the component is a common product with many lawful uses, such as a screwdriver or a smartphone, selling it is not contributory infringement. Knowledge of the patent. The seller must know both of the patent and that the component is made for infringing use. An example makes this clear. Imagine someone holds a patent on a specialized medical device. A competitor does not make the device itself but sells a custom part that only works in that patented device. Since the part has no other use and the seller knows about the patent, this would be contributory infringement. By contrast, if the part were a standard screw or a battery, which can be used in countless lawful ways, contributory infringement would not apply. A landmark case is Aero Manufacturing Company v. Convertible Top Replacement Company, 1961, where the Supreme Court addressed contributory infringement in the context of car convertible tops. The court clarified that liability requires knowledge that the component is both specifically made for infringement and without substantial non-infringing uses. Contributory infringement is often discussed alongside inducement of infringement. Both are forms of indirect infringement, but inducement involves encouraging or persuading others to infringe, for example, through instructions or advertising, while contributory infringement focuses on supplying non-staple components that make infringement possible. A curiosity about contributory infringement is that it has significant implications in technology and pharmaceuticals. For instance, selling software code that can only function in an infringing way, or manufacturing a chemical compound that has no use outside a patented drug formula, may expose a company to contributory infringement liability. These cases highlight how patent law reaches beyond direct actors to those who facilitate infringement behind the scenes. The consequences are serious. Contributory infringers are treated the same as direct infringers, facing damages such as lost profits or reasonable royalties. In some cases, if the conduct is egregious, courts may even award enhanced damages. In conclusion, contributory infringement is a doctrine that prevents companies from escaping liability by supplying specialized tools of infringement rather than infringing directly. By requiring proof of direct infringement, special adaptation, lack of non-infringing uses, and knowledge, the law balances fairness to patent owners with protection for sellers of ordinary goods. It is a cornerstone of modern patent enforcement in a world of complex supply chains and technology. Above, I leave you more videos so you can continue learning law. Remember to give us a like and subscribe.